Come to attention for our keynote speaker, Professor Orin Kerr, who is a professor of law at the USC Gould, is it Gould? Gould School of Law, clerked for Justice Kennedy in 2003 term. I know almost nothing about Orin Kerr other than he knows more about the Fourth Amendment than anybody I know. And I was asked to introduce him about 15 seconds ago. So with that, I turn it over to Professor Kerr.
All right. All right, it's a great pleasure to be here. Last week, Justice Kennedy called me, and in the course of our conversation, he explained that the fact he's not here was not meant as in any way an insult or commentary on me, which I greatly appreciated, and also took a little bit of the pressure off of me. I was ready for that Marshall McLuhan moment where I explain jurisprudence of Justice Kennedy, and he stands up and says, "Orin, you've got it completely wrong." So that would have been revealing, but much easier to talk without that. You may be wondering, why am I giving the keynote address, or a keynote address, and I think the answer is I was the last person to be able to free up a schedule to come, and so my remarks didn't fit any other place, and so it naturally stands on its own, or doesn't stand either way on its own. And the topic I have is Justice Kennedy and the Counter-Majoritarian difficulty, and this is going to be a combination of two different kinds of remarks. The first part is going to be about what I take to be the fundamental principles underlying Justice Kennedy's cases, jurisprudence as a justice, based both on his comments and on my impression as a law clerk. I clerked for the Justice October term 2003. That'll be the first part. And then the second part will be kind of a more academic reaction to what I take to be the justice's views. So the starting point of my comments is that Justice Kennedy, of course, is known for his vigorous view of the role of the Supreme Court in American life, and the statistics tend to bear that out. There have been some studies of the rate at which different justices voted to strike down legislative action, and Justice Kennedy, at least over most periods, was the justice who voted most often to strike down legislation. And if you think about the leading opinions for which Justice Kennedy is known, cases like Lawrence versus Texas and Obergefell versus Hodges, Citizens United, they're all cases in which Justice Kennedy wrote a majority opinion striking down a legislative act. Now, some believe that Justice Kennedy did not have a consistent jurisprudential philosophy that guided his best-known work, and I'm going to disagree with that. It's true that Justice Kennedy's opinions didn't fit the sort of classical narratives that are most often used today to judge how a Supreme Court justice ruled. Today, we often think in terms of whether what jurisprudential theory of interpretation a justice might have, whether the justice is an originalist, not an originalist. Different theories of interpretation tend to dominate our discussions of how justices rule. And then also we just have a sense of whether a justice is voting for the conservative side or the liberal side in some narrow political sense. Those are the ways we normally talk about a justice being consistent. And in those traditional terms, Justice Kennedy's work does not trace a straight line. But I think Justice Kennedy's views do reflect a consistent view of the Supreme Court's role. And it's a view that's really based on an understanding of the famous problem in constitutional law, the counter-majoritarian difficulty, which, as you probably know, is a phrase introduced by Alexander Bickel in his famous book, The Least Dangerous Branch. And so Bickel was really interested in the question of how is it that the Supreme Court can, in a democratic society, nonetheless invalidate democratically elected branch action. What democratic legitimacy does the Supreme Court bring to that? And so I'm going to make 2 points in my remarks. The first is that I think Justice Kennedy's view of the role of the Supreme Court reflects a particular answer to the counter-majoritarian difficulty, a proposed solution to it, which is really based on the idea that the public, the people, love the Supreme Court. They love the particular role of the Supreme Court, and they love the Supreme Court when it's exercising judicial review, and that gives a majoritarian role of the Supreme Court when it's exercising judicial review and striking down legislative action. Second, I'm going to offer my own take on whether that is a persuasive answer to the counter-majoritarian difficulty, and I'm going to argue that the view underlying Justice Kennedy's approach can be expressed in 4 different ways, and depending on what your assumptions are about the role of the Constitution and of democracy, I want to look at the assumptions on which Justice Kennedy's view is persuasive or not persuasive. Now, I'll admit at the outset, I'm a judicial restraint guy. I generally favor a more modest role of the Supreme Court. So I'm ultimately not persuaded by the argument of the sort of what I think of as the popular support answer to the counter-majoritarian role. But the reactions of one particular wayward clerk are not nearly as interesting or important as ultimately I think the views that do underlie Justice Kennedy's work as a justice over many decades. So where do I get this idea of what Justice Kennedy's views might be? And I think the most revealing answer to that is from a 2005 interview he gave to a group called the American Academy of Achievement. He gave an interview to this group, free-ranging, wide-ranging interview about his life and his views of the law and his views of the Supreme Court. And it was quietly posted on the web in 2005. And I remember coming across it, and this was just a year after I had finished clerking for the justice, and I thought, yes, this is Justice Kennedy's view, articulated here in a way much more clearly than anywhere else. And so let me talk about what that view is. He talks about the role of the Supreme Court, and he offered the following answer to the counter-majoritarian difficulty. He said, and I'm quoting him, "Most law professors and many commentators say that judicial review, the idea that courts can set aside legislation, is counter-majoritarian, so that a majority can't make its will binding on an injured minority." And he said, although that can be true in limited ways, if you look over time, he said, if you ask what the American people, the majority of the American people want over time, over our history, they want judicial review. They want to make sure that the promises of the Constitution are honored and that the commitments we made over time with our ancestors are followed. And then Justice Kennedy continued about his understanding, his vision of what people think about the Constitution. He offered the following vision of the role of the Constitution in American life. In his view, the Constitution defines the American people. Americans have their self-definition, their self-identity, shaped by the Constitution. The story of the American founding, he said, was that we rebelled against England because we wanted freedom. And the Constitution is the central document that reflects that identification. The Constitution, he said, is a formulation of what we think the principles of freedom are, and that's what defines America. And as a result of that, the self-image of an American relates to the Constitution, and the Constitution has acquired, and again quoting the Justice, the reverence of its people. So I think this understanding, these two pieces go together. The people love the Constitution. The Supreme Court is in effect the way that it's the institution that holds the rest of government to that promise of the Constitution and becomes part of this revered aspect of the Constitution that so many people will look to. And as someone, I often blog online and tweet online. I spend much too much time doing this online. I interact with a lot of people who have no legal training, and it's remarkable how often people have views of what the Constitution means. And this is something that has been poked fun at. The Onion had a very amusing story a few years ago of area man expresses his views of the Constitution. It was all these extremely passionately felt but completely absurd constitutional arguments. But there is an interesting part of that, which is that people, when they talk about what are their fundamental views of American law, it often boils down to what the Constitution may mean. So I think this understanding of the answer to the counter-majoritarian difficulty helps explain Justice Kennedy's views, and I think it both explains his style and his substance. So let me talk a little bit about Justice Kennedy's style. As you know from having read many Justice Kennedy opinions, they have a unique and specific style. There is a grandness to Justice Kennedy opinions. He writes of basic principles. He writes in somewhat abstract ways. Language can be flowery even. There are no footnotes. There's no extended responses to dissents. The opinions stand on their own without footnotes, without any ly words. Justice Kennedy never likes ly words in opinions. And there's a grandness to that. You've heard some of this, no doubt. Just thinking, look at the beginning of some of Justice Kennedy's most famous decisions from Lawrence versus Texas, phrases like liberty presumes an autonomy of self. From Obergefell versus Hodges, the Constitution promises liberty to all within its reach. These are phrases which to lawyers, naturally, those of us trained with wanting to know, well, what is the actual technical significance of a particular phrase? Some of these phrases can be frustrating, and lawyers will say, well, what does that mean? I don't know exactly what that means. And what's interesting, I think, is that I take Justice Kennedy to actually be speaking to a different audience, uniquely among members of the Supreme Court. If you talk to a non-lawyer and you ask them to read one of those paragraphs, often their responses will be, that is an incredibly important value, that is a meaningful concept to me, and I've learned from it, and they will see that part of the opinion as actually the one that speaks to them, and the very technical doctrine of distinguishing that case from that case, and reading a statute, parsing some language a particular way, as something which just comes off as a legal technicality. And I take from that Justice Kennedy's style was very much about teaching the public, communicating with the public about the Constitution and about the values underlying the Constitution. And I think that's consistent with Justice Kennedy's idea of the people revering the Constitution and of the court speaking to the promises of the Constitution. I think you can also see this underlying Justice Kennedy's substance. So Justice Kennedy, of course, one of the appointees of Ronald Reagan to the Supreme Court, had a very different view of the role of the Supreme Court relative to, for example, the Warren Court precedents relative to other Reagan appointees. So if you looked at the work of, for example, Justice Scalia or of Chief Justice Rehnquist, there's a sense in which their works, their views of the law were very much in opposition to the work of the Warren Court. So, whatever the Warren Court did in their big cases, there's a sense of like, well, that was wrong and here's why, and they had different answers to why. But there was a conflict between those particular justices' fundamental principles and a lot of the work of the Warren Court. Not so with Justice Kennedy. Justice Kennedy's work very much is consistent with and admires and even reveres the major precedents of the Warren Court. Think of cases like Brown versus Board, or Gideon versus Wainwright, or New York Times versus Sullivan. Justice Kennedy did not approach these cases from the perspective of, let's criticize these cases or underline or in some way sort of question them. They were very much a revered part of the Constitution, in part, I suspect, because they were part of the Constitution that the public revered, that had become part of that constitutional understanding that was so meaningful to so many people. And so I think that helps explain why Justice Kennedy, when he would approach these earlier precedents, he may want to cut them back somewhat. He may think a particular case went a little too far. And so I think, for example, in my field, criminal procedure, he cut back on the Miranda versus Arizona decision in a case called Burgess versus Tompkins. But although he would cut back on a major Warren Court precedent, he would not vote to overturn the Warren Court precedent. There was a sense that those decisions were just as legitimate, just as important to the fabric of American constitutional law as any other ruling, and therefore entitled to that reverence. Okay, so that I think is hopefully something that helps reveal some of the fundamental principles underlying Justice Kennedy's view. And I wanted to now turn to the critique part of it. And this is a little bit difficult because it's very difficult to critique answers to the counter-majoritarian difficulty because it's one of the most, or it is the most, written about problem in American constitutional law. And I don't even teach constitutional law. I'm a criminal law and criminal procedure person. And we're here at the symposium with some of America's foremost constitutional law scholars. And so the idea that I'm going to say something profound in response to Justice Kennedy's views and about the counter-majoritarian difficulty, I'm not going to. If you want to let your mind wander about how interesting the morning was or what you might be doing this weekend, feel free. I will not take any offense. But But what I wanted to do is offer what is no doubt an amateurish but hopefully well-meaning effort to figure out specifically what Justice Kennedy's answers to the counter-majoritarian difficulty might mean and offer some critiques of them. So I think the idea that the Supreme Court is not counter-majoritarian because the public loves the Constitution can be broken down into 4 different claims, and I want to treat them separately and look at some of the assumptions that are underlying them. The first is the idea that the public wants the principle of judicial review just as principle. This is what you might think of as the idea of judicial supremacy. When the Supreme Court speaks about what the Constitution means, other branches of government should follow. The Supreme Court's statements are authoritative as to what it interprets. And this is a very narrow understanding of judicial review and a narrow understanding of just what the public loves, sort of the judges get the final word. And for purposes of this particular answer to the counter-majoritarian difficulty, we should assume that the Constitution has very clear meaning and no one questions what any particular, everyone knows up or down whether a particular law is constitutional or not. Just assume that. I know that's a really tough assumption to make, but for purposes of this answer, we have to. If that's the case, does public support for the principle of judicial review solve the counter-majoritarian difficulty? I don't think it does because it more denies the problem than solves it. If the constitutionality of a government act is obvious and fixed, then a court exercising judicial review isn't so much counter-majoritarian in an obvious sense as it is trying to hold a polity to a prior promise. The basic idea is that when a polity enacts a constitution, it agrees to tie its hands. And if a court comes along and says, you've violated the earlier promise, you've violated the earlier limit you have imposed, and if it's absolutely clear what is constitutional and what's not constitutional, the court isn't really acting counter-majoritarian, it's rather just adhering to the earlier designation of the polity as to what should be allowed and what should not be allowed. And I think we can make an example of this with cookies. And there are those delicious chocolate chip cookies outside, which I hope you enjoyed. I did not have a delicious chocolate chip cookie. And the reason why is I'm trying to lose a little bit of weight, get in better shape. And let's say I asked you, please make sure I don't eat any cookies. And if you see me over trying to eat a cookie later, could you just grab the cookie from my hands? And let's say after this talk, I'm over by in the back there, and I see those cookies, and I'm like, wow, those look really good. And I go to eat a cookie, and you snatch the cookie from my hands. Are you acting against my will? Well, in some sense, yes. In some sense, no. You're not acting against my will in that I actually asked you to do that. I asked you to snatch the cookie away from me because I don't want the cookie. Now, on the other hand, the me that is grabbing the cookie may want it at that moment. But if we're asking whether that's against my will, you have to ask, well, is the relevant will the moment that I said, here are the rules, or the moment that I grabbed the cookie? And if we have this limited understanding of judicial review, then basically the Supreme Court is grabbing away the cookie. And it's not counter-majoritarian, really, because it's just sticking to the earlier promise, an earlier promise which I think is inherent in constitutionalism, that there will be set rules for what a government can do, in my example, whether I'm grabbing the cookie. So that's not really a counter-majoritarian problem, and I suspect that's not the heart of the debate over the counter-majoritarian difficulty. The next possible answer is that maybe the public wants the results of judicial review. That is, maybe what makes the public love the Constitution and love the Supreme Court is that over time, the decisions of the Supreme Court tend to match public preferences, at least at a national level. And so Barry Friedman has written powerfully about this in his book, The Will of the People. And Friedman writes, essentially, that there's a basic alliance between the Supreme Court and national majority opinion, such that the Constitution, as interpreted by the Supreme Court, comes to reflect, this is Friedman's words, reflect the considered judgment of the people regarding their most fundamental values. And then from this perspective, perhaps the people self-identify with the Constitution because the Constitution is actually reflecting the will of the people. They're seeing themselves, in effect, when they love the Constitution. And if this is right, is the Supreme Court then no longer acting in a counter-majoritarian way? Well, in some sense, it's now acting in a majoritarian way, if you take that assumption, in that the court's opinions are aligning to some extent with majority national preference. So in that sense, the court is sort of giving the public what the public wants when it's acting in that way that echoes majoritarian opinion. So that's possible, but I admit I'm not really convinced by this argument, because it seems to me that if we're going to measure whether a rule is majoritarian, we have to factor in the level of government that we would think would ordinarily be assigned that particular legal issue. So we're not a national polity where we have just one government. The Constitution is made up of member states that, of course, agree to enter into the Constitution and to give up some of their sovereignty in exchange for some amount of national rule pursuant to the terms of the Constitution. And under that system, some issues are federal, some issues are state, some issues are local. But it seems to me that the Supreme Court, to the extent it's acting consistently with majoritarian rule at the national level, is still counter-majoritarian in some sense, because it's acting in a way counter to the majority at the state level, to the extent we're dealing with issues that are properly a matter of state law. From that sense, what the Supreme Court is doing when it's acting in a majoritarian way is really it's federalizing decisions. It's taking decisions that were at the state level, imposing a single national federal rule, and it may be that that rule is consistent with the majority preference considered nationally, but it would be inconsistent often with state level, local level majorities where the decision had earlier rested. Therefore, it strikes me that this understanding of the counter-majoritarian difficulty has the Supreme Court acting as a majoritarian rule nationally, but in a counter-majoritarian way still at the state level where it may be that those decisions are properly made. Finally, this approach to the understanding of the counter-majoritarian difficulty also leaves open the question of why do we need a Supreme Court that is nationalizing issues of American law? And if we want an institution to nationalize the law, aren't there better ways of doing that than through a Supreme Court, especially one made up of unelected judges who can strike down laws but not enact laws, and therefore are going to potentially have a bias in one direction when they do exercise judicial review. So that's a possible answer, I think, to the counter-majoritarian difficulty, but one subject to the questions of what is the proper unit of government that we look to measure whether an institution is majoritarian or not. A third possible answer, there's only two more, I promise, almost done. A third possible answer is that the public supports the interpretive method that the Supreme Court uses to exercise judicial review. And so maybe the public supports a particular theory of interpretation, whether it's originalism or some other theory, such that when the Supreme Court exercises that particular interpretive theory, that the Supreme Court is acting in a majoritarian way because it's carrying out the preferences of the public in terms of what view of the Constitution they would like implemented. And I think this is, if it's true, is a plausible answer to the counter-majoritarian difficulty, but at least the evidence that I've seen suggests that that's not how most people think about the Constitution. There's not a lot of polling data on this, but there's one interesting poll from 2008 that surveyed 1,000 adults. This was on the road to the 2008 presidential election. And here was the question they asked. Should the Supreme Court make decisions based on what's written in the Constitution and legal precedents, or should it be guided mostly by a sense of fairness and justice? Not a great polling question. For lawyers, say, wait a minute, they're mixing up whole schools of thought there. But this was what they asked the public. And what was really interesting is that there was a division based on who people were supporting for the presidency in terms of what they tended to answer. So 82% of those that supported the Republican candidate for the president, John McCain, said that the Supreme Court should decide cases based on what's written in the Constitution and legal precedents and not what's based on a sense of fairness and justice. On the other hand, 29% of those who supported the Democratic candidate, Barack Obama, agreed with that view. So they're very much a partisan divide, or at least a who people intended to vote for the presidency divide. And I think that reflects how the Supreme Court is spoken of in the political system. So typically, Republican presidents have spoken in terms of the Supreme Court shouldn't make the law, it should follow the law. That was the refrain of President George W. Bush, and others have made similar comments. On the other hand, Barack Obama, perhaps best known for his view that in close, difficult cases, it's important for a Supreme Court justice to have a sense of empathy, that empathy should play an important role. And now, most members of the public, they're not lawyers, they don't have any sort of depth of thought in terms of these interpretive schools, but I suspect the answers to the poll suggest that most people were echoing what they had heard their side effectively say about how the Supreme Court should interpret the Constitution. And I think that's probably true also of lawyers. So I suspect most lawyers, and even perhaps law professors, to the extent they have a sense of here's the correct theory of interpretation that should be brought to the Constitution, they probably have a sense of there's certain results which echo their views that they feel passionately are important and are so fundamental to what the Constitution means, and then they look to what methods are sort of generally aligned with that particular set of outcomes, and then they're naturally drawn to that theory without maybe thinking particularly deeply of what does that theory truly mean, what are the implications of that approach, and the like. And if that's right, it's not so much that the public has an interpretive theory. That may be the concern of law professors, legal academics, but it's probably not something where there is a coalesced sort of American vision of how to interpret the Constitution that the public loves. That's probably not what is driving the American love of the Constitution. The final possible answer to what the public may love when they love the Constitution is maybe they love the Supreme Court's persuasive power in its opinions. So from this perspective, maybe the Supreme Court leads public opinion rather than follows, and maybe what the public appreciates is the wisdom that the Supreme Court imparts that helps the American people settle these very difficult fundamental questions in American life, which the Supreme Court occasionally steps in and settles. Again, if this is a persuasive, if the evidence backs this view up, then I think it offers at least a partial answer to the counter-majoritarian difficulty, in the sense that maybe judicial review and the role of the Supreme Court is majoritarian because the court itself is persuading the American people as to the fundamental values that, from which they should live. The evidence for this view is, I think, at best mixed, however. There's a lot of empirical work, polling, studies that have been conducted to try to figure out to what extent does the Supreme Court deciding an issue alter public opinion. And it's really hard to summarize all this information, but let me just point to a couple data points. In general, the evidence that I've seen suggests that the Supreme Court's decisions don't substantially impact public opinion. So there are a couple different pieces of information on this. One, Thomas Marshall wrote a book in 1989 in which he looked at polls of public opinion going back from the 1930s through the 1980s on policy issues that the Supreme Court then weighed in on, and compared public opinion on those policy issues before the Supreme Court's ruling and after the Supreme Court's ruling. Marshall found that the Supreme Court's decisions did not make a difference in public opinion, at least in that relatively short time window before and after the Supreme Court had ruled. He wrote, the polls shifted away from the court's opinion more often than toward it, and the average poll shift was almost zero. So at least that's some reason to be skeptical that the public is sort of learning its values from the Supreme Court and being persuaded by it. There also have been some studies that have been conducted of, for example, college students that are called in and told of hypothetical Supreme Court opinions and asked after they hear of this hypothetical Supreme Court opinion, what do you think of this important policy question? And the students are then asked, or these days it's like done on Mechanical Turk basically online, has this changed your view of the policy question? And there's some evidence that there's a slight shift to some people, but it's primarily a polarization rather than a shift in median public opinion. And what tends to happen, at least these results have suggested, is that folks who were enthusiastic about the Supreme Court and sort of walked in the door with a sense that the Supreme Court was great, they would be more enthusiastic about their prior held views than they were before. Sort of the Supreme Court echoing their opinion made them all the more confident that their prior opinion was correct. But there is, in a sense, at least from the studies that I've seen, that people really change their minds. And I think this sort of echoes what we experience today, whether it's in public conversations, online, on Twitter, where I spend way too much time. If you tell someone the Supreme Court ruled a particular way that sort of conflicts with their deeply held values, most people don't say, now I need to rethink my deeply held values. Instead, they say the Supreme Court was wrong, they were political, they're illegitimate, they're just a bunch of politicians in robes, or whatever the argument is, typically resisting the Supreme Court's action, even if, of course, accepting that the Supreme Court is the Supreme Court and as a practical matter is the final word. I think people are less likely to be persuaded by the Supreme Court than to conclude that the court just got it wrong for one reason or another. So in conclusion, Justice Kennedy's opinions don't fit in the most common ways of thinking about the Supreme Court that commentators use today, whether it's interpretive theory or just political dynamics left and right. But I think there is a consistency underlying his approach, rooted in a particular understanding of the counter-majoritarian difficulty and this idea that the people love the Supreme Court, love the Constitution, and that the Supreme Court taking this significant role in American life is consistent with the reverence that the people have and that the people want the Supreme Court to take that role. And I hope that this understanding helps reveal at least a little bit the assumptions underlying Justice Kennedy's opinions and a significant amount of his work as a justice. So thank you very much for listening. Time for questions? I want us to point out it was originally a donut hypothetical, but there were cookies out there, so I made that last-minute shift.
He is better to the alcoholic who says, I don't want to have a drink. And if I go have a drink, I want you to stop me. And you say to the person, are you really sure? Do you really mean that? And the person says, yeah, I really mean it. It's horrible. It's horrible. Let me just tell you how horrible it is. Sometimes I'll say I want to drink, but you need to stop me because that's not me. And I wonder if that goes any further to supporting one of Justice Kennedy's rationales, or is the hypothetical unfair?
Great. So I don't think it's unfair, and I think it's another way of restating the problem. It's helpful in that it makes clear that the first judgment was the sober judgment, right? That's the one that we should credit because the person was of their full faculties, and then the later decision was an impaired decision that we should not consider as significant as the first decision. And I'm sympathetic to that analogy for purposes of the role of understanding the role of constitutionalism. And in both cases, though, I think the key idea is that the court is really only holding someone to a bargain. It's sort of, the nature of it is somebody saying, I'm going to tie my hands, please help me, setting up an inherent conflict of wills between will at time one and will at time two. And so a decision that the will later is inconsistent with the first one and the first one trumps is not really against the person's will. It's just enforcing that initial will. So in that sense, if you interpret the Constitution in that way and you think everything is crystal clear, then the court really is not acting as counter-majoritarian. It's just holding the government to its initially expressed will. And of course, the difficulty with that is that we know that the cases that people care about are not the ones where the Constitution is crystal clear. So that's why I think that ultimately more denies the problem of the counter-majoritarian difficulty rather than answers it.
Professor Kerr, thanks for that great talk. I'm wondering how intensity of preferences fits into all of this. So I think everybody agrees that on the big high-profile issues that came before the Supreme Court that people care about, Justice Kennedy sometimes made one side of the political spectrum happy and sometimes made the other side happy. Suppose you were to go to people on the left and say, okay, you can have Obergefell and the abortion cases, or you can have the outcome you didn't get in the other cases, Citizens United, Shelby County, those other big high-profile cases that went the other way. At least based on my intuition, I suspect a lot of liberals would be happy with the way those cases actually came out. And the same might be true on the other side with at least some set of conservatives. They would be more, they're happier that Citizens United and Shelby County came out the way they did than if they could have traded those cases for the same-sex marriage and abortion cases, just to take a few of those examples. So in that sense, is Justice Kennedy's jurisprudence maybe not counter-majoritarian in that on the issues that people care about, that on both sides they really care passionately about, he may be sided in some way with maybe a minority, but a minority that really cares passionately about their views on that issue? Do you have any thoughts on that?
Interesting question. So I don't have a great sense, sort of case by case, as to how different decisions have been interpreted. It's also difficult with some of the major decisions like Citizens United that I think have their own life in public that's often very different from what the case actually held. You know, many of you have probably had this experience of talking about Supreme Court cases, in my case, Citizens United specifically, with family members, neighbors who are not lawyers, and their sense of what the case held. And you're just like, no, that has nothing to do with what the case held. So it's difficult to kind of say, I think, to answer what's majoritarian or counter-majoritarian when there's so much public misunderstanding. But I think it may be that Kennedy's views are ultimate sort of big decisions were majoritarian in many ways, whether it's public opinion as a whole or maybe negotiating some path between left and right in terms of both sides being relatively pleased with the work on the whole. Hard to say. My sense, though, is that even if that's true, that's kind of nationalizing the level, the unit of measurement in a way that I don't think we should when trying to answer the question. So, but I take your point. It's an interesting one that maybe Kennedy managed to sort of please both sides more than he displeased them in a way that is hard otherwise to do. That's certainly possible.
Maybe it's not that he pleased one side and one set of cases and another side and another set of cases. Maybe it's that with him on the court, you had a chance. Everybody had a chance, and you didn't know necessarily what the answer was going to be. And it's what set the court apart from the other two branches of government. And I'm wondering if that might be part of what his legacy could be. And I'm wondering whether you think that what the prospects are for the conception of the court in that way will be for the future.
You can ask me a simple question, Gary. So I think there's definitely a sense in which Justice Kennedy was a throwback to an earlier era. Post-1995, or whatever cutoff date you want to say, we have much more of a polarized sense of different justices on different sides, and we walk into the big cases knowing, or at least being pretty confident in our assumptions as to which justices will be on which side. And Justice Kennedy was the swing vote in the sense, I agree with this, that he was more open-minded. He would take each case as its own and say which outcome here would really fit my vision of the Constitution. And it's fascinating to me that on cases, whether it's same-sex marriage or other sort of high-profile cases, it's just sort of everyone walks in the door like this will be a Kennedy decision. Why? Well, because the other 8 votes are absolutely certain. No one's going to question where the other 8 justices are going to come out. It boils down to Kennedy because there's that assumption that everybody else their views are going to be known. So in that sense, I think it's true that he came to every case with an open mind, and every case was open in that sense. And I think you see this in particular with his questions at oral argument, and the style that Justice Kennedy asked at oral argument. And when I was a law clerk, clerk for another justice said to me about midway through the term, it's so interesting. Justice Kennedy asks questions, and it's like he's really asking what's on his mind. And I thought, well, right. I mean, and a lot of the justices were asking tactical questions. A lot of the justices, this was at a time when Justice O'Connor was also on the court. Basically, what are questions that I can ask to frame the debate in a way that might appeal to Justice Kennedy or Justice O'Connor, sort of trying to form a majority through questions to the advocates. And Justice Kennedy would ask the same questions on the bench that he would be asking to us as law clerks, and he really had these questions on his mind. And it was refreshing at oral argument, when he would ask a question, he'd say, "This is what's bothering me." That was truly what was on his mind and truly bothering him. And so there was an openness and a sense of openness to persuasion that I think was rare. And also, I think in part, a luxury when you don't have to persuade other people because you may be so often the deciding vote. So that certainly makes it a little bit easier. But I do think there's a way in which he was a throwback to this earlier time where you didn't quite know where the justices were going to come out on some of the key issues. So many issues which were framed to Justice Kennedy himself as well. And we'll see if Chief Justice Roberts takes this role or not going forward. All right, thank you.